A long-running dispute over the security of an individual's privacy and private information on Facebook will be settled in a European court later. It's part of a campaign by the Austrian activist Max Shrems to ensure data is kept secure as it crosses international boundaries. Well, to explain more, let's go to Brussels to speak to our correspondent, Shona Murray. Shona, this is all about Europeans' data when it gets transferred from outside of Europe to, let's say, the United States, and about the protections that should be in place for it. So just explain, what are the sort of details of the case and more importantly, the implications of it?
Well, the implications could be huge in terms of how data is flowed between organisations here in Europe and across the globe. It could also have huge costs for businesses and, of course, legal uncertainty. And as you mentioned there, Rosie, it is a long-running case. It's been going on since around 2013, and it was spurred on really by the revelations made by Edward Snowden a few years ago in relation to personal data protection. But to explain a lot more, I'm joined now by Matthew Newman, who is a data protection expert from MLEX here in Brussels. You're welcome, Matthew. If you tell us, what is this case about? What does it mean?
You mentioned Edward Snowden, and Max Shrems is the Austrian activist who started this case. He's a Facebook user, and he said back then that the safe harbor agreement between the US and the EU was illegal because it did not protect the data privacy of European citizens. He won that case in 2015, and now this is what we call Shrems 2, because once the European Court of Justice invalidated the Safe Harbor Agreement, then Facebook and other companies turned to another mechanism, and that's called standard contractual clauses. These are model contracts that were designed and written by the European Commission that ensure that the data protection rules are enforced and protected when, let's say, Facebook's users have their data transferred to California, and he's saying that those contracts are just as problematic as the Safe Harbor Agreement. And at the same time, he's saying that the Privacy Shield, which was the successor to the Safe Harbor Agreement, is also invalid. So it could be a double whammy by the court today.
So what is the court going to rule on, and what are the implications of either ruling?
Yeah, so there's two main things, the standard contractual clauses and the Privacy Shield. Now, the court could only rule on one of them, or just say, like, look, we're not even going to handle the Privacy Shield. They don't have to do that. It's in their discretion. There was an opinion that was put out in December 2019 for the court, which said that the court does not need to look at the Privacy Shield. That would be great news for companies here in Europe. There are many, many small companies that simply do not have the capacity, the money, the resources to hire lawyers and think of new ways to transfer their data. So they rely on the Privacy Shield. So it would be a real disaster if that was invalidated. Now, if the standard contractual clauses are invalidated, then the Commission is going to have to scramble to rewrite them, redraft them, and that will cause a huge amount of legal uncertainty for companies and potentially disrupt international data flows.
So huge ramifications. We'll get that ruling at around 9:30 this morning. Matthew Newman, thank you very much for joining us. And back to you in the studio, Rosie.